on.
Good afternoon. This is the International Arbitrage in Oistins, Barbados on the 22nd of September 2023. They said 2003 there. And today we're going to be talking about raising funds in the US, especially if you are a non-US person, a non-US business owner, and you want to raise less than $100 million in the United States from high net worth investors. If that is what you want to do and you have a non-US business, I've explained in previous videos some of the challenges that you will have from with US investors and the banks and the trustees and their compliance departments. The first thing you have to realize, especially since the new private fund advisor rules have come out, is basically that these new rules have made it such that there's a lot of investor protection. The fiduciary obligations, the amount of reporting that is required, all of this is increased with the SEC's new rules and regulations for private fund advisors. Private fund advisors in different terminology is investment managers. If you are an investment manager of a non-US business and you have it set up in a private investment fund and you are regulated, you have a regulated fund manager that you might set up somewhere which is running an investment fund, and then you're trying to raise money from US investors, you're going to have to put some of your structure, some of your investment fund structure on the ground in the United States. We're not going to talk today about the tax implications of doing that and how you can mitigate or reduce the tax implications of setting up a investment fund that has presence in the US. If you have a office and various service providers and other presence in the US in order to be able to deal with US investors. You also have to register your offering with the US Securities Exchange Commission under Regulation D, which is basically the US regulator. You have to do all these things, and that amounts to presence in the United States. Now, there are going to be potentially tax implications from doing that. So what we're more talking about is the implications of the private fund advisor rules. The private fund advisor rules mean that there's much increased investor protection for US investors. The increasing protections they're contractual in nature. They are in the law of tort or the law of negligence, which means that if you as an investment manager act negligently with regards to investors' funds, they will have legal recourse against you. And then finally, the most powerful obligations of all, the fiduciary obligations. And in particular, the new private fund advisor rules have been changed to require that the fiduciary obligations are included, that they're not limited and cut out of investment manager agreements. So if you're raising funds in the US from US accredited, or as we call it, sophisticated investors, these are the types of standards that you will expect and have to agree with in your dealings. And these obligations have become even more in point due to the new rules and regulations. And so what you have to think is, how am I going to be able to meet these obligations and deliver this kind of investor protection to be able to raise funds in the US? And we will go more into detail of how you actually do increase investor protection. But let's say in summary that what you end up doing, if you have an office and a company and other involvement and staff and people, officers based in the US, then you have legal exposure to investors in the US. And ultimately, that is what is going to be required in order for you to raise funds from US investors. And if you have funds if you have funds in the US, you have assets in the US, and let's say you have personal funds and assets in the US also. Your family may have funds and assets in the US. Many owner managers from Latin America also, in addition to doing business in the US, they set up funds, use US private investment banks and other institutions, and they keep a lot of their wealth and hard currency in the US. But if you're doing business in the US and raising funds from US investors, if you run into any problems, you could ultimately be subject to US litigation. So the number one thing that owner managers should do before they set up or start raising funds in the US is make sure that you have a trust set up for you and your family. I'd say, for instance, what you might want to consider is the implications of setting up a trust in the US versus setting up a trust outside of the US in a place like Belize or Nevis or somewhere else. And the reason you might want to do this is because the US jurisdiction is very litigious, the rules are very strong, the courts take a long time to go through, and judgments can be very expensive. And so what you might want to do is consider having a trust and funds booked outside of the US to increase your asset protection. Currently today in the US, mainly 19 jurisdictions or states within the United States have legislation that say that settlors, which is the person who sets up a trust, if they have any recourse to the trust or benefit from the trust, that creditors are unable to attack those trusts. But that only exists in 19 states so far in the US. It is true that many good jurisdictions like South Dakota, Nevada, Delaware, and these places do have trusts that are protected, especially if it is settler interested or the settler has the right to income or other benefits that could be quantified and made liquid. So these are things that you need to consider. So basically, if you're raising funds in the US, you have all of your wealth or a lot of your hard currency wealth in the US at US private banks and US trusts, you definitely want to consider that. I have come across many families, Latin American families with trusts all over the US, not necessarily in the 19. Many people do set up trusts in South Dakota, Nevada, Delaware, and these places, but there are also people set up in other states. So, but if you set up an asset protection trust in the US, your assets can still be subject to litigation. Your trust can be subject to litigation. US litigation costs money. So you might want to consider setting up a trust and your wealth management arrangements, or some of them, outside of the US, so that if you do end up in litigation with your investors in the US, that not all of your wealth would be subject to litigation or caught up in litigation and would be free for you to use to basically keep things going or sort things out. So this is just some thoughts from me on international structuring. As I say, in general, I think that non-US persons definitely have to think differently to US persons when it comes to all the things that they're doing, including raising funds in the US from wealthy US investors who have the ability to put you and your fund in court and go after your any and all assets that you may have in the US. Okay, that's it for now from the International Arbitrage here at Oistins after attending Moe's Grill to pick up some fish and chips. Thank you.